first case to come before the court today is City of Akron v. Lizett, Alvarez. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. If you do plan to reserve time, please let me know so I can keep track of the time. Arguments are being recorded, so please stay behind the podiums, introduce yourselves, and keep your voices up. You should not use the names of children or minors or victims during your argument, and you can refer to those folks by initials or general terms. The judges have read your briefs and are ready to proceed when you are, and I would just ask the appellant, would you like to reserve time?
Good morning, Your Honor. Yes, I'd like to reserve 3 minutes for rebuttal, please.
You may proceed when you are ready.
May it please the court, Louis Grube here on behalf of the defendant appellant, Lizett Alvarez. Defendant Lizett Alvarez was held in contempt for failing to turn over one of her dogs for euthanasia. The only evidence admitted at the hearing on this contempt was that her boyfriend had taken one of the dogs, Puma, and Alvarez had turned over the other dog, Bruno. It was an abuse of discretion to hold Alvarez in contempt because the evidence only supports the view that she was unable to comply with the forfeiture order or purge the contempt, and the conduct of another had rendered her violation inevitable. I'd like to start off with a little bit of background to give a sort of roadmap today for the arguments. We actually have 2 arguments. The first being that it was an abuse of discretion to hold her in contempt, and the second being that really this was conduct by another person and there is no vicarious contempt under Ohio law. So I think perhaps the most important thing here is that nobody really thought that she had the power to presently turn over the dog when she was held in contempt and when the purge condition to turn over the dog was imposed on her. So everybody believed the dog had been stolen. The judge actually said that twice between 3 pages of transcript.
Can I ask you, counsel, how did you come to be at court that day? How did you know to be at court that day when
I wasn't trial counsel, Your Honor.
Okay.
My understanding.
How did counsel know?
I think that there were some phone calls in the background. There is a reference in the transcript to the judge hearing from trial counsel that the dog was not available to be turned over. The judge does reference at one point, I heard from your attorney over the phone, I think. I recall this from our brief. I didn't look at the transcript again last night, maybe I should have. But my understanding is there were communications around this. There were discussions between the prosecutor and the dog warden when the dog warden showed up. Obviously, she wanted 2 dogs. She had an order telling her to take 2 dogs. She was confused about what to do since there was only 1 dog. And she actually did accept the 1 dog once the judge changed the order to permit her to accept 1 dog. So my understanding is that there were communications in the background that are sort of off the record around this. I didn't flag that as an issue, I guess, of notice. I know that there was an objection to any sort of criminal contempt since there had been no advance notice that the contempt could be criminal, but my understanding is that...
Do you consider this indirect civil contempt?
Yes, and I don't think there was any argument to the contrary. This is out of the presence of the trial court. This is civil in the sense that this is not to punish any misbehavior. It was conditional. It's civil in the sense that there's a purge condition. She would not have actually had to pay the $50 a day fine for failure to comply. And so it's a pretty classic indirect civil contempt in those senses.
Do you know if Ms. Alvarez was present when the contempt finding happened?
I thought she was in court, yeah. That's my understanding from the transcript. I may have missed something, Your Honor, so if, I guess I'll find out in the decision. No, my understanding is that she was present with counsel. Counsel was advocating strongly on her behalf. Back to the background, though, I think it's pretty... The key factor here is that the judge was willing to recognize that it sounded like the dog had been stolen twice before imposing this contempt, suggesting that maybe a police report was in order. And actually, the city made a similar concession. I'm just going to read you, this is from pages 18 and 19 of the transcript, from the city's counsel. I don't believe either that she was purposely trying to hide this dog from animal control. I think at this point it might even be prudent for her to even potentially file a police report about the missing dog, as it sounds like there might be some interference with the court orders on behalf of another party and not on behalf of this defendant. And I think that perfectly encapsulates our 2 arguments. If the court understands and recognizes that the dog has been stolen and it is not in the possession of the defendant, even though she's had this order to turn it over, how could she possibly conceivably comply with an order to turn over property that she does not have anymore? So with that understanding of the facts, it is an abuse of discretion. It's like, okay, you don't have the thing I want, so turn it over or I'm going to fine you, or fine you. It's a classic abuse of discretion. There's no reason behind it. It's a failure to recognize the conclusive facts when fashioning an order to deal with them. And I can't imagine a more obvious abuse of discretion than that. If your facts don't match up with the order you're imposing on a person, that's an abuse of discretion.
So is an impossibility a defense to contempt? And then if the judge is free to believe or not believe that it's impossible for her to comply with the court order?
Yeah, I mean, there was some briefing about that in the state's brief. What I would say is that, or the city's brief, the city asked a couple questions. This is like 3 questions. And for the impossibility defense, my client does bear the burden. But when you've got all the evidence you need in the record, you don't have to put any more evidence on. I mean, it's not the kind of thing where the judge could say, well, I have some reason to believe that you're hiding this dog. Nobody testified about that. There's no facts there. There's no evidence supporting that inference. And in fact, she turned over the other dog. So, what's the purpose of hiding this one dog if nobody thinks she has it, which that's true. Nobody came in, nobody with knowledge, nobody with the capacity to offer facts into evidence testified that she still had this dog, or had offered any reason to believe that she was in a position to prevent the dog from being turned over. And all else we have is efforts to comply with this order during a confusing time where the dog warden didn't know whether she could take one dog rather than 2. So you'd have to pin that fact finding to a fact, and that's the problem in this case. There's no other fact. There's no contrary fact. So it's not like a balancing, weighing situation. There's just nothing there for the judge to rely on to make that fact finding, and that's why it's a classic abuse of discretion. Imagine a summary judgment case, right? All the evidence is on one side, and then the judge decides, well, I think based on the background, I think it could go the other way, without identifying any particular fact. There's got to be something in the record supporting a finding, and that's kind of the basic point under that. But even if that weren't the case, the other problem we have in this case is that everybody was sort of willing to recognize, and the evidence conclusively supports the idea that really the boyfriend, this other person, took this dog and prevented my client from complying with this order. And we relied on 2 cases. The city's argument in response is that the 2 cases we relied on are actually prohibitive injunction cases. They're orders to the court saying, don't do a thing, and somebody misbehaved, rather than this case where the court said, do this thing, and then the person wasn't unable to do that. That's the city's argument. Can't disagree more. Both of those cases had elements of both prohibitory and compulsory court orders. So in the Fagan case, there was an order to, it was like a gag order, classic gag order. Don't talk about this case. We want a good jury pool for the defense. Don't talk about the case. Glenn Fagan was the supervisory attorney. He was under this order, but he didn't misbehave. He didn't go talk to the press. He didn't protest like his subordinate had. He was under an obligation to comply with it's like the trial counsel, like the lead counsel rule, which required everybody who was lead counsel to supervise their employees and make them comply with court orders. So he was under an active obligation to do that as trial counsel. It's no different than this case. My client was required to turn over the dog. Glenn Fagan was required to compel his employees to behave in court. So there's really no distinction there. And Glenn Fagan hadn't done anything. Glenn Fagan had actually counseled all of his employees to follow all court orders. That's why the first district vacated it. He hadn't actually done anything wrong. Only his subordinate had. And so, that seems like a one-to-one comparison. I even think that the North American Coal Court case that we relied on from the Sixth Circuit it's got similar elements. That was a union case. The district court issued an order compelling everybody to stop picketing, to stop interfering with work, and then the union leaders were held in contempt for failing to convince their employees that they represented to stop picketing. You know, they were under an obligation to supervise, very similar to the Fagan case. And because they had actually tried to comply, because they had done their best to comply, because they had directed all the employees under their supervision to go back to work, the court basically said, no, you know, the Court of Appeals told the district court, no, you're holding these people in contempt for failing to get somebody else to do what they were supposed to do. This is vicarious, truly vicarious contempt. And so, you know, the parallels are, I think, pretty obvious, but I guess to just walk it through very slowly, in this case, Lizett Alvarez was told, turn over the dogs. In the Fagan case, Glenn Fagan was told, supervise your employees. In the North American Coal Court, the union reps were told, make sure that your union stops picketing and gets back to work. And when all three of them were unable to accomplish that, they were held in contempt. It's a classic vicarious contempt, and you know, this distinction, I also, like, if this court sees it differently, if this court sees North American Coal Court and the Fagan case differently, that those were prohibitory injunctions, this is a mandatory one, you know, the court orders you to do something rather than not ordering you to do something. In the preliminary injunction world, in cases where the Court of Appeals is reviewing an injunctive order, there's this breakdown of the distinction between a mandatory and a prohibitory injunction. You know, obviously courts can, there are limitations on orders, but like, what's the distinction? What's the distinction between prohibiting somebody from doing something and compelling them to do something when it is in the court's power to do that? You know, and for contempt purposes, what we're here for today, contempt is just a violation of a court order. What does it matter what the underlying order says, do or don't do? Also, if the city were actually going to back up that argument that there's some distinction to be had there, they should have a case for it. You know, there are no decisions in their brief that would support that distinction. So I just don't understand that.
I think you could find case law though, because technically dogs are property, and there's probably court orders where the court orders them to turn over property, correct? And if it's in your possession?
If it's in your possession, sure. I mean, yeah.
And obviously if she's pled guilty to a dangerous dog, the dog is in her possession and she is the owner.
The dog was in her possession and she was the owner at the time of the underlying offenses. So then the question is, does she still have the dog? Can she still turn it over? What is the reason for her failure to comply? And if it's impossible for her to comply, that's a good defense. There's 5 or 6 cases in our brief that say that, and the city was not able to, you know, provide a single case saying that there's any distinction for the purpose of this analysis between a prohibitory and a mandatory court order. So that would be, you know, I'm just trying to establish that. I mean, certainly my client had the dog at the time when the dog misbehaved. We're not appealing that today. We're just focused on the contempt order. With that, I reserve the rest of my time unless there are any more questions. Thank you.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. I want to address a question you raised. Ms. Alvarez was present at the contempt hearing. There are points in the transcript where the judge specifically says you, referring to the defendant, talking about how it's convenient for you that the dog suddenly disappeared, and that she was present there and he was addressing her directly.
Can you, while we're on that, can you address whether or not there was written notice of the hearing?
Your Honor, I do not know. That was not an issue that I looked into because it wasn't raised by the appellant in this case. I know that there was a discussion as to whether there's a written notice of the hearing. I do not know that that is in the record or not. I also wanted to briefly address I guess taking a step back and looking at the contempt proceeding generally speaking. What happened here is a civil contempt proceeding. It was indirect, so there needed to be evidence of a court order, knowledge of the court order by the defendant, and then that the defendant failed to comply with the court order. Those are the 3 elements necessary for a finding of contempt. In this case, there was a court order. It was issued on September 7th, ordering Ms. Alvarez to turn over both dogs. Ms. Alvarez was present at that hearing when this order was issued, and she was told verbally, you're going to have to turn over both dogs within 24 hours to animal control. And then 3, when animal control contacted her, she did not turn over both dogs. She told them she would only turn over one of the dogs. She gave a further explanation saying, my boyfriend has absconded with the other dog. That was her verbal representation to the animal control officer. And that's what prompted the proceedings to reconvene on September 9th. So this is all over the course of 3 days.
And how was that communicated to the defendant?
I do not know, Your Honor. I am not, like I said, it was not an issue that was raised, so I didn't
Well,
look
there
at
was
that.
an objection, right? I mean, as I seem to recall, there was an objection by counsel, defense counsel, to proceeding with the hearing because his client hadn't been provided written notice. Is that wrong?
Your Honor, I believe that objection is in the record, and I think that is correct. But I also think that written notice is only required for criminal contempt, which that was part of what was going. And if you read it sounds like you've read the transcript of this hearing or this argument, and I think that there's a tenor in this of the contempt proceeding where defense counsel, in giving a vigorous defense, is trying to catch the trial court in a gotcha. They're trying to say, what are we here for? What are we here for? And the court says, it's fine, it's criminal. And then the court ends up giving a civil contempt sanction at the end. And that was actually an objection that the counsel made was, well, you said it was criminal, so you can't give me a civil contempt finding. Well, that's not how that works. The criminal is, you have greater protections in a criminal contempt finding proceeding because you can be found in contempt and go to jail. Whereas a civil contempt, you have a chance to purge, so you have fewer protections leading into the actual hearing. And what ended up happening was the parties went forward on the record, and the prosecution established all 3 elements of the contempt: order, notice, failure to comply. The burden then shifted to Ms. Alvarez to establish on the record that she had a good defense. That is her burden, and this idea that the record doesn't establish anything other than that is, that's where I said in my brief that there was a shifting of the burdens here. Because there was no requirement that the prosecution put on evidence that her defense was bad. She had to convince the court that her defense was good. And that's why, under the facts here, it's not an abuse of discretion. Because, yes, if the court accepted the story as told through the animal control officer, the court could have found a good defense. But it was not required to accept that testimony, because that testimony, as the court pointed out repeatedly, was incredibly convenient. These dogs had remained in this defendant's control for months. The first incident was in May. The second incident was in June. This proceeding happened in September. And on September 7th, when they were in that courtroom, that she had control of the dogs. On September 8th, suddenly her boyfriend has reportedly, according to her, taken one of the dogs. And now suddenly she doesn't know, she can't contact him. This person she's seeing just won't return her phone calls. And the judge points out, basically, I don't believe this. Like, I just do not believe this. If this was true, you would have filed a criminal complaint.
But does the judge say that?
Yes.
He says, I don't believe this?
Yes, he said this is very, like, he says this is just too convenient. Like, I don't know if the court comes out directly and says, I do not believe this testimony, but the court says, it goes into the idea of, this is convenient, I find this very suspicious, and then says, it sounds like it's theft, you should be filing a criminal complaint. The court's not saying it believes her, it's pointing out kind of the flaw, and again, the court's speaking from the bench. It's happening in a moment of, I would describe as frustration based on everything that's happened here, where this dog suddenly disappears. She's acting like the defendant is taking position, I don't know where it is, and she's not even coming forward and testifying about that, which is her right. But if she's not coming on and testifying, the court is able to still weigh this testimony is coming through a secondary witness.
Did the prosecutor have anything to say on the record about whether or not the prosecutor believed Ms. Alvarez had attempted to surrender the dogs?
I believe the prosecutor's position on the record was that she believed Ms. Alvarez. The prosecutor, however, is not the trier of fact in this case. And I think, and frankly, I think that explains some of the questions the prosecutor asked. I think the prosecutor in this case was attempting to help Ms. Alvarez, but contempt is about the power of the court, not about the prosecutor. And it's an unusual circumstance, but the court is the trier of fact here. The court has been sitting on this case for months, and the other thing I will point out is that the dog that was surrendered was the dog that was represented in the record as being abused. They had been adopted from an abusive household, and there was a representation made that this was the dog that actually did all the attacking. The other dog that was not surrendered had been with the family since it was a puppy. It was a beloved family pet. It was the one there were pictures of it cuddling with their children at the hearing. So again, the court kind of had this background knowledge of the fact that the dog that was being turned over was the one that they were saying was the actual one at fault, and the one that wasn't being surrendered was the one that was the preferred pet, essentially. And so again, it was convenient that which dog was not being turned over is the one that they wanted to protect the most. And that's, again, goes into this whole thing of the court just didn't have to believe this testimony coming in through a third party. The animal control officer did not see the boyfriend take the dog. The animal control officer did not know what happened to the dog. The animal control officer only knew what had been represented to her by the defendant. And in this case, the court could listen to all that and say, well, I just don't believe that, because it's just too convenient. And then in finding her in contempt like the court did, that's clearly what the court found. And that's why it's not an abuse of discretion here. It's a high burden, and on this record, it's not unreasonable for the court to simply not accept this out-of-court statement from the defendant. And I know that defense counsel is pointing out that this could be classified as an out-of-court admission by a party opponent, but it's also what's unusual about this is it's not really admitting anything. It's a defense. So it's not really offered against the opponent. It's actually offered in support of her, and it's a very unusual. It doesn't go to prove an element of contempt. It actually goes to try to disprove it. So that's why I'm not sure it fully falls within the hearsay exception that it would typically be offered in. And then finally, the other issue.
The clock is over.
Oh, wait a sec.
Go ahead.
Finally, the other issue with the distinguishing the other cases. The other cases were the people were being found for failure to control their actual employees, their members, their other people in the case. And while Ms. Alvarez is taking the position, my boyfriend took the dog, she still had the obligation to actually turn the dog over. And until she actually established that her boyfriend took the dog, that is the distinguishing factor between those cases that are cited by the appellant and this case. And again, yes, if you weigh the evidence and if you take it in light most favorable to Ms. Alvarez, it would support a defense. But the court's not required to do that. The court can weigh the evidence, believe any, all, or some of the testimony, and the court, by finding her in contempt, clearly did not believe the testimony that the dog had been taken by someone else. And at least to the extent that she was not involved in the dog being taken. Because maybe the boyfriend did take the dog, but I think the court could also say, well, probably her request. So that's, again, some of the underlying circumstances here, which is that whatever happened, the dog didn't get turned over, and the court just did not find that she met her burden to prove that it was an impossibility or that it was a good defense to what happened. So, if there are no further questions, we would ask you to affirm the court's decision.
Thank you, counsel.
Thank you.
And I apologize for the clock.
Mr. Bermer's a good colleague. He can have all the time he wants. Judge Sutton, to your question about notice, I did just find, I think it's on page 6 of the transcript, that the judge does say that notice came through counsel for Ms. Alvarez. I want to reframe this. It's not in a situation where there was really any doubt whether the dog was taken, despite Ms. Alvarez's hopes, obligations, what she was planning on doing. this isn't a case where the judge doubted that the dog was stolen. This is a case where the judge said on the record no fewer than 2 times that that probably is what happened. And I'm not relying on evidence that my client needed to even put into the record. We're talking about an answer to a question that was posed by the city. There was no objection. It's a statement by a party opponent. It's admissible, and there's no evidence to contradict the truth of that statement, which was offered merely against my client, although it does establish beyond doubt her defense here. Now, on page 20 of the transcript, the judge says clear as day, as I spoke with the prosecutor and your attorney yesterday, if you don't know where the dog is, then your boyfriend should be charged with theft, or ex-boyfriend, because he took the dog against your will. But that's not something, but that's something the prosecutor has to do. The only doubt the judge really had about this was whether anything was going to happen about it. It's because the judges and the prosecutor isn't responsible for bringing theft charges. Then on page 22, sounds like to me it may have been a theft. This is set against a record where even the city's prosecutor in the room was willing to recognize that it was probably a theft and that my client probably wasn't trying to willingly avoid the court's direction for her to obey. So this is well rooted in the record. I'm just asking the court to see what's in the record, to recognize that all of the evidence conclusively points to one conclusion, that this dog was taken against my client's will and that she did not have it to turn it over at the time that she was obligated to turn it over, and that in light of that fact, civil contempt requiring her to purge the contempt by doing something not in her power is an abuse of discretion. It's as simple as that.
What about opposing counsel's argument, as I hear it, that the result speaks for itself, that's, that the judge has the right to believe or not believe, and obviously with the outcome as it was, that...
Again, this is not like an inference that obviously follows from any specific fact. The convenience of the moment, the random happenstance, I mean, it's shadows and guesswork. There's no fact that the court is relying on. This is not something, there's no fact in the record that points to the inference that she was playing a part in this. The dog, all the evidence we have, and these are questions that the city elicited, this is evidence that the city brought in its own attempt to hold our client in contempt. All of that evidence directs to the dog being stolen. Everybody recognized it. I'm not arguing that this is a situation where the judge could have done one thing or could have done another thing. I'm saying that in the room, the judge, on the record, reflects on the fact that he thinks the dog was stolen. And in light of that factual view from the bench, it is an abuse of discretion to punish her for failing to do something that she simply couldn't do. There's no, fact-finding thing here. The judge knew what happened.
You're going to need to wrap up.
Yes, with that, we would simply ask the court to reverse.
Thank you very much. Thank you both for your presentation. The court will take the matter under advisement and issue a decision in due course that will be mailed to you by the clerk of courts on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again.
Thank you.